Can I own a gun if my spouse is a felon? A viewer asked that excellent question in a comment section on one of my other videos, so I'm going to address that here. Welcome to Lawyered Up. I'm Patrick McGee, and I'm a Florida trial attorney and former police officer, and I bring you Second Amendment and firearms related news and information from around Florida and around the country. So, can I own a gun if my spouse is a felon? Well, let's set this question up with some facts. So, let's say you're married to Betty Lou, and you thought Betty Lou was going out on Wednesdays playing bingo. But in reality, Betty Lou belongs to the Blue Hair Gang, and she's going off with her buddies on Wednesday nights and knocking off liquor stores. So Betty Lou gets nabbed, and her buddies get nabbed. She does her prison time, and she comes back home. She's a convicted felon now. Can you, as her spouse, own a firearm? Let's take a look at the statute that plays a part in this analysis. Florida Statute 790-23 of the Florida Statutes, felons and delinquents' possession of firearms, ammunition, electric weapons, or devices are unlawful. The pertinent part, it is unlawful for any person to own or to have in his or her, and here's the important part, care, custody, possession, or control of any firearm, ammunition, or electronic weapon or device, or any concealed carry weapon, including a tear gas gun or chemical weapon or device, if that person has been number one, convicted of a felony in the courts of this state, and it goes on to list other felony and delinquent acts, but basically if you're a convicted felon, you cannot have in your care, custody, possession, or control any firearm, ammunition, or electric weapon or device, or any concealed carry weapon, including a tear gas gun or a chemical weapon or device at all. No ifs, ands, or buts about it. So the spouse cannot have possession, care, custody, and control of that weapon. But can you, as the spouse of that convicted felon, own a firearm? Yes, you can. Well, it's a little more complicated than yes, you can, but yes, you can. The Second Amendment still applies to you because you're not a prohibited person. It applies only to the spouse that is a felon. So the main point here is the care, custody, control, and possession. And in Florida, there's two types of possession. There's active possession and there's constructive possession. Active possession is when it's something is in your hands, it's in your pocket, it's on your body. You have actual possession of it. Constructive possession is if you and Betty Lou, or Betty Lou takes your car, let's say Betty Lou takes your car out for a drive and you left your gun under the seat. Now Betty Lou is in constructive possession of that firearm and in violation of the law. So you have to be able to have control of the firearm and control the access and possession, both types of possession of that firearm to keep it away from Betty Lou. So how do you do that? You either have to keep the firearm on your person constantly. You can't put it in a drawer. You can't lock it in a trunk. You can't put it anywhere in the house that Betty Lou would have access to it, basically. So under those circumstances, you would not be able to have the firearm in the house. You can still own it, but you wouldn't be able to have it in the house. The only way you could have it in the house is if you put it in a safe and Betty Lou does not know the combination or have the key to the safe, and you're able to absolutely control access, control, and possession of that weapon or weapons. So it's a difficult, not clear-cut answer to your question. Yes, you can own a gun under certain circumstances. You can have it in your house. Another thing you have to consider is if Betty Lou is on probation, her probation order may state that there's no weapons in the house, but more importantly, her probation contract is also going to state, and her probation order is also going to state that her probation officer can come in the house at any time and search. So that's a waiver. So you don't want the probation officer coming in and finding something that violates not only Betty Lou's probation, but maybe a criminal act in your part. So for a safe bet, you wouldn't have a gun in the house at all. But if you must have a gun in the house, you must be able to control access, possession of that weapon. And the only way you can do that is to keep it under lock and key if it's not in your actual possession. I hope that answered your question. There's a few cases which interpret that, and that's the gist of everything. It's a very much more detailed issue than what I've tried to explain here. I've tried to make it common sense and easy to understand by hitting the highlights of it, and I hope I was successful in that. And please, if you like this type of content, like and subscribe. I'll see you next time on Lawyered Up. Have a good day.